why make the same mistake?
Right.
And if you want to continue making that mistake, then don't complain,
Right.
because we're going to do what we think is right. And what's right is to make sure the information is disclosed. We are in efficient markets. We believe that information trickles down on the stock price, and that's why it's important. For example, projections. How can you not have projections? And even though there's been a turn in including more projections, we still see transactions where proxies don't have projections, like the case Ramtron that my firm is litigating. Unfortunately, that was a denied preliminary injunction, but I think there's something in the background, but we're pursuing that on a quasi-appraisal now, asking for those projections to be
Now,
disclosed.
would you think 96% of all proxies are materially deficient in disclosures?
I think there's a good number. I don't know if I would say all 96%, because our firm doesn't do 96% of the deals.
It's Randy's firms that are.
I don't think I don't think Randy's firm. I'm going to defend Randy here. I don't think Randy's firm does 96%. I think there's a lot of deals that unfortunately neither Randy or myself are handling. So maybe that's part of the problem as well. But but look, the proxies make the same omissions. You can't complain that the plaintiff bar is going to keep coming at it. I think it's commendable, our persistence, so I will applaud ourselves here.
Well, all right. Now that
That's that. Now you want to go on? Yes.
So now let's get into a little bit of the nuts and bolts of this multi-forum, multi-district situation. Juan, tell us, when you're deciding to bring a case, and you've got a variety of choices of venues, you've got federal court, you've got state of incorporation, you've got state of principal place of business, you may have other alternatives for venue. How do you go about making that decision?
So certainly the process begins as you describe. What are the states where we can sue? Is it going to be the state of incorporation, one of them? Yes. And is it going to be where the company's headquartered? Yes. And then within, are we going to state level or to the federal level? I think the first issue that you want to discuss with the client, the shareholder who's retaining you, is what are the courts that are available? How sophisticated are those courts? Delaware Chancery Court, certainly everyone knows, is very sophisticated, and a lot of these cases are litigated there. But there have been also courts that have developed a similar sophistication, like Santa Clara has that ability because it has a complex department. In New York, we have also a commercial division. So I think the first question is, do we have a sophisticated court? And you want to be in a sophisticated court, because I think a lot of problems sometimes you encounter if you don't go to a court that has seen these issues or has the ability to absorb them. It's going to be to your prejudice, because these cases move so fast. And even if you have a judge willing to learn, it's just not possible sometimes in such a short amount of period to learn, for a judiciary to expect it to come up to speed, and there's a learning curve, obviously. So I think the first issue is the sophistication of the court. And then it's going to be an issue of what kind of client do you have? Is there a client who is in the locality where the company does business and wants to exert some political or media pressure? We do see that sometimes, that being an issue, especially if you have an institutional investor that wants to make sure they rally up the locality. It could be that there is former employees. It could be that there's even employees who don't like the deal. We saw that was an issue in Sovereign Bancorp, where the settlement really ended up being that the bank buying Sovereign was not going to lay off 1,000 people, I think. Pennsylvania, that was the state, and that has a constituency statute. Also, you want to know, if you're outside a Delaware Corp company, is there a constituency statute? Meaning, are you supposed to challenge just that the board did not maximize shareholder value, or can the board then defend themselves that they're entitled to also look at other issues like their constituency, their employees, how society may be affected by this deal? That would be a different approach. And also speed. That's going to be really an issue. Is this a tender offer or not? If you need speed, you got to make sure you have a sophisticated court, but also a court that not only sophisticated, that has vehicles in their civil procedure or in the ways they do business to be able to get in front of that court tomorrow or in 2 or 3 days if you need to, because time is going to be an issue. So I think those are a number of the factors that you will consider, and the client will have to decide. And lastly, the client sophistication. Does the client understand these issues. Because if the client does understand these issues, you're going to be able to have a much more productive discussion. And some clients will actually come in and tell you, these are the breaches we see, this is what I think we need to do, and this is the strategy we think we need to undertake. And they'll want to really work with you on the strategy and the locality where you're going to be filed. So I think it's a multi-factor process.
Sure.
And also there is always a reality, a practicality is, are you late to the party? Are you early to the party? Are other people already organized? Firms, there's a reality the plaintiff firms will look at that issue of whether you're going to be able to have an active role, because why else file a case? You don't file a case if you don't want to have an active role. At least that's my view, and I think that view is shared by a lot of people in the plaintiff bar.
Makes sense, sure. What about federal courts? When do you consider them as a better alternative to filing in state court?
Well, I think, for example, Virginia, you have no choice since they don't have a class action statute in the state level. So knowing that, it's helpful. I think also there are some states, and I think that deals more with companies that are not incorporated in Delaware, when you're going to have to deal with let's say, a Texas statute, or you're going to have to deal with an Ohio statute. There may be some benefit for federal court. I know we did that in DPL, and our firm was lead, and we took the case forward in federal court. And again, I think one of the benefits you have in federal court is the speed and the court's ability and willingness to get involved that you may not find in some other states, either because they're overwhelmed with the docket, they don't have a specialized commercial or complex division, and they're going to struggle with that. So why do that? You do have a responsibility to the shareholders and the class at large to make sure you go to a place where you can get their attention, and sometimes federal court, that's the place where you can get federal attention, especially, like I said, if Delaware is not an option.
Sure. Now, in my experience, most of these cases, and obviously it depends on the state you're in, as you say, have been brought as class actions, but you also see, particularly in the larger deals, simultaneous filing of class actions and derivative actions. So can you just share with us your thoughts on the filing of derivative actions and when those are appropriate, or your preferred strategy in pursuing a merger litigation?
Yeah, I think the derivative angle, I mean, everyone knows if it's a deal case and you have a derivative claim, that's going to die if the deal goes through.
Right.
Except there's some states, like I referenced earlier, Texas, Maryland, Ohio, by statute, they might require you to have that derivative component. So certainly you're going to have to do that there. I know there is litigation going on right now challenging the Freeport litigation, McMoran and Plains exploration, where you have all claims that one could conceivably think of being brought simultaneously by different firms. So I think that's an odd situation. I don't think that's the normal situation. I don't think derivative angles are as frequent as perhaps you might see in the past. I think there's been plenty of trouble for the plaintiff bar to keep those derivative claims post close, and it's been rare the occasion where a constructive trust has been successful in order to maintain that claim going forward.
Sure, understandable. Well, you actually raise an interesting question when you start to talk about post-closing litigation, and we're going to talk about this at various panels later in the day, but let's just assume that you have a crystal ball and you have a reasonable sense at the beginning of a case as to how likely it is that the case is going to be litigated post-closing as a damages case, as opposed to the principal action being in a preliminary injunction situation up front. Assuming you know that, how, if at all, does that affect your calculus as to what court or courts you want to be in? How does that just affect your overall strategy in bringing the case?
I think, despite our efforts to keep working on this great crystal ball that is not panning out, I don't think you know. I think you want to file where you think your case has the best chance of succeeding, and I don't think you go through all the scenarios of whether it's just a preliminary injunction, settlement, or damages. I think you look at it in the aggregate, and quite frankly, cases that you may think when you file maybe were not going to be as strong as you thought, they develop into a strong case. So that's why it's important that you file in where you think is the best court from the start.
Right.
Because a case is like a human to some degree. You never know where it's going to end up. It's going to evolve into something different. So I don't think you help yourself by handicapping or hedging what the case is going to end up, the outcome of that case. I think you want to say, let me go the best place for the case overall, and the case will develop in its best way, shape or form that way.
So you don't find some jurisdictions are better for preliminary injunctions, but others are better for overall damages, or is it? I mean, again, we don't know. We don't know how a case is going to develop, obviously. But let's just, if we assume you did, are there some courts where you'd rather be trying a damages case and some where you'd rather be having a PI heard?
I think absolutely. I think I go back to what I said at the beginning. You want to be in a sophisticated court, whether it's Delaware or outside Delaware. You want to make sure the court that has the case is going to get it, because you're right. A preliminary injunction is going to be something that the judge is going to be a hard time, for example, granting, and he's going to make sure that it makes sense granting it. So you got to have a judge that comprehends the law and is willing to use the law. And same thing for damages. If you're going to have a case going, you want to make sure you're in a jurisdiction where that happens. Our experience with damages cases has been more in the Delaware courts. Last year we had Playboy and Cogent, and there's others. So certainly from our perspective, we have been doing those cases in Delaware, but there is other cases that perhaps do better also outside Delaware because of the court sophistication. So I think that's the main issue, is make sure you have a court that will understand the issues both pre-closing and post-closing.
Okay. So before I get the defense perspective from Ken, how do you view your role in terms of not overburdening the judiciary with multiple forum litigation? Do you think that the plaintiffs in bringing this suit have a responsibility to limit the burden on the judiciary, and if so, how does that play out?
Certainly, and not only do I think we have a responsibility, the plaintiff bar as a whole, but I do find it surprising sometimes when the judiciary takes offense, because we are exercising our responsibility. We had a circumstance, without getting into the details, where that precisely occurred. We were asked to coordinate with an outside jurisdiction, and we did, and then once we coordinated, the defense group was not happy with the outcome that the plaintiff wanted to proceed in one type of jurisdiction and wanted duplicative injunctive proceedings to go on. So I do think we have a responsibility, and we take it seriously, and we try to avoid, and I think a lot of briefing that we have been doing, we precisely say that in response to some of the one-for motions or motions by defendants for people to either one stand down or the other one to proceed. We say we're happy to coordinate with the other jurisdictions. So I do think we have a responsibility, and we try exercising it.
Okay, great. Well, we're going to ask you to chime in as Ken and Neal are going through the various things that they're commenting on. Maybe I don't even have to ask you, but I'm
very shy.
I know you are.
Thank you for telling me.
I'm going to try and fight that inherent shyness. But Ken, let me turn it over to you for a little bit. So you're representing a defendant in a case. You've got litigation pending both in the state of incorporation and in the state where which is the principal place of business. Just walk us through your thought process in advising your clients about what to do next and how to deal with this problem of having litigation in multiple forums.
Sure. So the first thing I do is I wake up from my dream, because 5 years ago I had a dream that we did a disclosure, and I got a letter from Juan and another one from Randy, and it said, "You got everything right. You did it perfect. We've read it. We can't find a thing wrong with it." So I still haven't gotten that letter, but when I do, it's going to be framed on my wall. So I wake up from my dream, and lo and behold, I've got litigation in Delaware. I've got litigation in California. I've got, maybe federal court, maybe state court. So what's the first thing that I do? Well, the first thing is, do these people know about each other's lawsuits? And look, there's a question. I mean, sometimes they don't know that there are other lawsuits pending, and sometimes there's a question of whether we should tell them. And there's a danger, perhaps, in getting the plaintiffs together because actually sometimes they do agree on a single forum, and sometimes they might agree on a forum that isn't the one that you as a defendant would have chosen. So I think the first question is, do you sort of give them the opportunity to get together? And I think we usually do. I mean, I can't think of a time when we haven't. I think there's a couple of reasons for that. I guess we're not narcissistic enough to think that we're going to cause them to get together in a way that wouldn't have happened otherwise. So we might as well let them know they're going to find out anyway. The second thing is, as you go forward, it is very helpful to be able to say, look, we tried to get these people to coordinate. We asked them to coordinate. I frequently will write a letter or send an email, gee, will you guys decide on one forum?